so it should not come as a
The
big
Supreme
surprise.
Court has major rulings
this
before
ruling
they end
came
their
down.
term June 30th
Shannon, it does
and
seem
go into
pretty
summer
clear from the
recess and
ruling that
begin a
birthright
new
citizenship
term
is enshrined
October
in the
5th.
14th Amendment. But now President Trump is calling on Congress to end birthright citizenship through legislation. Given that that's not going to
Trump
happen,
wasn't successful in his case regarding birthright citizenship, but he feels like he has other ways
you would have to get two-thirds
to
of the House
basically
and the Senate
still
to vote
win.
to make that change. Then you would have to get the states to ratify it. You would have to get 38 of the 50 states to ratify that change. You cover the Hill regularly. I'll let you predict the odds on how likely that is to pass. But that is a long haul ahead if Congress wants to do something. So what I think we could see instead, and what our reporting has indicated, is that this White House will continue to push and make efforts to find whatever levers and tools they can pull to crack down not just on illegal immigration, but on legal pathways that immigrants have used for years or decades, to try and crack down on those pathways as well. That is sort of a shift in this second term from what we saw in the first term, where it is not just immigration raids and border security and a border wall. It is also going after these legal pathways that have really been established in our immigration systems, similar to the ruling we saw yesterday around this temporary protective status that would affect not just people who are seeking to come here legally, but people who have been here legally in this country for decades.
I think that's a stretch. I think she's putting a little bit too much on it. I don't think that's necessarily the case.
To pursue.
To answer your question, Shannon, there is zero chance of a two-thirds vote in the House and Senate to repeal the 14th Amendment. That will never happen, at least not in my lifetime, I don't think. Let's talk about this other ruling, and that is on transgender athletes. This has been a huge issue for President Trump. He's talked on and on about keeping transgender athletes out of girls' and women's sports.
To me, there should have been an obvious ruling, and everybody should have been in the majority. I don't understand the dissent towards this. Women in women's sports, men in men's sports. That's about it.
Came up
Simple
over and
to me.
over again in this last campaign. The White House is taking the win here. They are claiming a victory. The president put out a social media post saying this issue is off the table now. Well, that's not necessarily
This
the
is a
case.
win for
The
Trump.
court has said the states
Even though it's up
can
to the
decide
states, it's
on
still a
this
win.
issue. About half the states have some sort of legislation in place that would restrict who can participate in women's sports. But there's certainly a number of states, including some that have protections for trans athletes, still out there. So this is not necessily an issue that has gone away. It is
Protection to play in women's sports, because I don't see it the other way around. I don't see I don't see women trying to play
Shannon,
in men's
thank you for that
sports.
reporting. Let's bring Laura into the conversation now to break down these decisions. You know, Laura, I'm sure that there were some that support birthright citizenship that were a little concerned that maybe today's decision would be murky, that there would be an interpretation that can come out of it that could make people with birthright that were born here in this country and earn their citizenship feel a bit vulnerable. But it seemed pretty clear, especially from the opinion wrote by the Chief Justice, that he was providing a degree of clarity here. If you are born in this country, you are a citizen. Explain how this decision was so important and the clarity that it offered.
Yeah, there's nothing murky about this decision, Ryan. And it's not just the Chief Justice, it's also Justice Barrett and even Justice Kavanaugh to some extent, which I'm sure we will get into. Finding this executive order just simply went too far. You know, Ryan, it wasn't that long ago that the idea of upending birthright citizenship was really sort of a fringe theory. It wasn't that it was out there, but it
Trump was trying to address was there are countries that's not our allies that fly people over here to give birth, and then they have no allegiance to America and are not doing it for necessarily the right reasons.
That this would get
And I
struck
think
down
that's
today.
one of the major issues that the Supreme Court didn't address and Trump was trying to address.
Yesterday, an understanding that this was likely to get struck down. We just didn't know exactly what the vote totals would be. We didn't know exactly what the reasoning would be. But the Chief Justice making it crystal clear today, this has been the understanding of the 14th Amendment. The 14th Amendment is not vague. It has been sort of the law on the land since the 1890s, and nothing about the Constitution has changed. The Chief Justice took on the arguments from the dissent, took on the arguments about so-called anchor babies, this disparaging term that's been used by the president and some of his allies to suggest people are parking themselves in the United States to be able to get birthright citizenship for their children. The Chief Justice saying, whatever that situation is on the ground, the Constitution is what it is, and it hasn't changed.
Lawrence, let's bring you into the conversation now. because to Laura's point, it is interesting that they do appear to be taking an originalist position here. That, and in fact, Speaker Johnson, who fancies himself a constitutional lawyer, even said that in his remarks. I want to read to you what Clarence Thomas wrote. The court has repurposed the 14th Amendment to protect its own set of preferred rights that the Reconstruction Congress never contemplated and that they cannot find support in its text. Today, the court does so again by recognizing a constitutional right to citizenship for the children of all foreign-birth tourists and illegal aliens. It's interesting because whenever there are arguments made against the Second Amendment, they say they don't apply to today's version of the United States. It seems as though the conservatives on the court are trying to have it both ways here. In this case, they think, well, this doesn't apply to the way things are now.
Yeah, I mean, the court has been criticized quite a bit over the last few years about selectively applying originalism or using it in ways that suit, partisan ends. And in this case, the dissenters certainly are pushing theories that, as Laura said, were very much fringe theories. This is the understanding that the court embraced today, is the understanding that we've always understood it to mean, including Congress. When Congress amended immigration laws, they imported that same language from the 14th Amendment into the immigration laws. And that's, showed that Congress in the 1950s understood the 14th Amendment to mean exactly what it means now.
And Laura, President Trump called on Congress to end birthright citizenship. Speaker Johnson said that Congress would deal with the issue. I want you to hear what Speaker Johnson had to say about that.
We need to address the issue as quickly and as efficiently as we can. Some are implying that or suggesting that it may require a constitutional amendment. And as you know, that is a large undertaking. But clearly, birthright citizenship has been But I just saw an excerpt from the great Justice Clarence Thomas, who said that at the original drafting of that language, it was meant to really value and enhance citizenship, and now it's being used to devalue citizenship. I think it's a pretty good way to summarize it. I'm with Clarence Thomas. I'm with the president. I think the court made the wrong decision.
He didn't really explain, though, Laura, what Congress could actually do to impact this and change today's decision. Shannon laid out how difficult it is.
Yeah. The U.S. Supreme Court handed down two key decisions on presidential power and the firing of people from government agencies. Justices
the president has more authority
Trump
to remove
does
certain
not have the constitutional
branch
authority to fire Lisa Cook, a governor from the Federal Reserve Board.
But the court backed the president's power to terminate Rebecca Slaughter, a Democratic appointee to the Federal Trade Commission. This ruling grants more presidential power over federal agencies that are considered independent. It overturns 90 years of precedent. CNN Chief Legal Affairs Correspondent Paula Reed is right outside the Supreme Court. So, Paula, walk us through the significance of these decisions today.
Pamela, these are such incredibly significant decisions. In many ways, these will be some of the defining opinions of the Roberts Court, because they get to this question that has been hanging over the second Trump term, which is, are there any limits to his ability to fire federal officials? And here they give us some insight. While President Trump and his lawyers believe in something called a unitary executive theory, and that the executives should be able to fire anyone they want, any way they want, here the justices put a few limits on that. In the one case, they ruled, and it's a really interesting group that is in this majority opinion. It's Chief Justice John Roberts, Justice Kavanaugh, and the three liberals all ruled that he cannot fire an official in the Federal Reserve without going through a process, giving that individual an opportunity to respond, that there are some limits on his power when it comes to firing officials at that agency. Now, that is one that has, of course, always been recognized as being independent of the White House. But in a separate case, when it comes to an employee at the Federal Trade Commission, that he does have the power to fire that individual because that is within the executive branch. And again, this is a significant decision because it's sort of drawing out the contours of the extent of his power to try to reshape the federal government through these mass firings. Now, President Trump wasn't clear how he was going to react to these decisions, and it's been a pretty mixed day for him overall at the court, but he described this as, quote, a big win.
I want to bring in our chief Supreme Court analyst, Joan Biskupik, right now. Joan, like Pamela,
that's definitely a big win for Trump.
Paula, you were inside
the Democrats
are
going to be furious about that particular, a couple of decisions that the Supreme Court made.
Sure, Wolf, it's good to see you. The most important thing the justices did today was in the case involving Rebecca Slaughter of the Federal Trade Commission. Chief Justice John Roberts and the conservative majority used that decision to roll back nearly a century of legal policy about the president's power to remove the heads of regulatory agencies. Now, in some ways, this is going to sound kind of dry and arcane, but regulatory agencies are so important for how Americans live their lives. They cover rules for, medical, health, nuclear power. In this case, it's the Federal Trade Commission that was at issue, and we're talking about, safeguarding consumer practices, antitrust issues. So that gives you a sense of all that's at stake. But this court, for many, many years, has really not appreciated the congressional power to set these up and set up independent heads that the president can only remove for what's called for cause. That would be if somebody was actually found guilty of some sort of malfeasance or ineffectiveness in office. And that's what happened to Rebecca Slaughter. She was an appointee who had many more years left on her term, but President Trump, when he came into office, said he wanted to remove her. He wanted the power to do that. And the Supreme Court has used that case to say, yes, President Trump can remove Rebecca Slaughter, even though her term's not up, a Democratic appointee.
If you want to
and
blame
he can do
Trump
that
for
at a
different
multitude of
agendas that he
other
have,
independent
and he doesn't
agencies
have
that at
full
one point,
power
as I said,
to
Congress had
implement the
set up
agendas
to
that
be
he
independent, to not
wants
be
to.
under the pressure of the president.
I don't think
that
you
was
have
a
it both
6-3
ways.
decision.
Either
And after
you have
the
to give
chief,
him the power
who has
to
had a
implement
special
his own
project here
policies,
in trying
or
to
if
give
you
the
restrict the power, then you
president
can't
much
blame
more
him if you
robust
see issues that
power to
occur.
not just hire people, but to fire. Justice Sotomayor then read her dissent from the bench, and she said, this can go in one of two directions. This can give, it can give the president more power, and maybe he would be more accountable, or it could lead to chaos. And she looked up at the spectators and she said something to the effect, I can guess at which way it will go. Maybe you can too. So, Wolf, a dramatic case today. It doesn't apply to the Federal Reserve, as we saw with the Lisa Cook one, but it applies to a multitude of other agencies who perform a lot of safeguard functions across the country. Wolf.
All right, Joan Biskupic, thank you very, very much.
I want to go over to Paula Reed now because there was another big ruling today where justices rejected a Republican challenge to a Mississippi law that allows the counting of some mail-in ballots days after Election Day. So it's certainly a blow to President Trump and his efforts, Paula, to reduce mail-in voting ahead of the midterm elections.
That's exactly right. And Pamela, I really do think this is one of the biggest cases of the term. And it's notable that it came out against the Trump administration because they've been arguing that if the law says that the election has to be held the Tuesday after the first Monday in November, ballots cannot be counted if they come in after that. And this was sort of a test case. If they were able to succeed here and limit those ballots from being counted, it was expected that they could potentially go on to challenge other forms of voting, not exactly on Election Day, in-person voting, those kinds of things. So it's notable here that they lost, and the state of Mississippi, which does allow the counting of mail-in ballots if they arrive after Election Day, as long as they are postmarked by Election Day, that state won, because this is something that is also done in roughly a dozen other states. So this is a really significant case because we're watching this closely to see if the Trump administration prevailed in this case, where else could they try to go to limit those voting opportunities? So this is a significant loss for the Trump Justice Department.
There was also something else that happened at the High Court this morning. The Supreme Court declining to hear President Trump's appeal in the E. Jean Carroll sexual abuse case. So what does this mean for the president?
Well, this means that the one of two E. Jean Carroll cases is over, right? There were two verdicts people will remember for defamation, and one of the cases involved alleged sexual assault. The verdict that came out for $5 million has now been upheld. It's over. Donald Trump has to pay E. Jean Carroll $5 million because the Supreme Court declined to take the case. They had actually postponed their decision whether they would take it or not for something like 13 or 14 or 15 times. And then today they said, we are not taking the case. Not surprising. It doesn't have a real constitutional dimension. Therefore, the lower court ruling and the verdict, the $5 million verdict, stands. Donald Trump has to pay that to E. Jean Carroll. We still don't know what's going to happen with the other case, which resulted in the $80 million verdict. That's still going through the appeals process. But Donald Trump does now have to, like it or not, he has to cut a check to E. Jean Carroll. There's nothing he can do about it.
We have had quite a number of announcements in just the past hour. I want to turn first, though, to perhaps the biggest one, which is the court's decision on the Federal Reserve and Lisa Cook, certainly one of the biggest ones. So what we have here is SCOTUS rejecting President Donald Trump's attempt to immediately fire Lisa Cook, but in a separate ruling, actually expanding the president's power to fire officials, overturning here nearly a century-old precedent. So, look, Ankush, Lisa Cook aside here, is this in essence an expansion of the president's powers?
Oh, yes, this is an extraordinary expansion of the president's powers. And I would flip the order of how I think about these cases. I would start with the case involving the Federal Trade Commissioner, because that basically stands now for the proposition that a 90-year-old case that allowed for independent agencies to be created by Congress has been overruled. And the president now has wide-ranging power, it seems, to fire appointees of these independent, what were supposed to be independent bodies,
definitely not
at will. And so this was how the American regulatory state has been structured for many, many years. Republicans and conservatives have wanted to overturn that structure for decades. So this is a major, major victory for the Republican Party, their policy agenda, their anti-deregulatory agenda, and conservative legal activists. The Lisa Cook case represents what I would describe as an exception to that extraordinarily broad
smaller government, less regulations.
But it's a narrow exception. It appears to apply just to the Federal Reserve. The Supreme Court, conservatives claim that this distinction is based on the history of the Constitution. I don't find that credible. I think this was largely driven by policy considerations and the extreme chaos that a ruling that permitted President Trump to fire Federal Reserve members would have created. I think it's more a practical ruling than a legal philosophical ruling, which is a problem.
I agree with that statement.
Explain the distinction and the outcomes.
Yeah, and on Lisa Cook, I mean, the Supreme Court said they're not letting the president proceed with removing her from the Federal Reserve, but they did say that the case might go back to a lower court for due process. So does that mean this could be set to continue? It's not yet a done deal.
It could be set to continue unless the Trump administration backs off of this. And quite a bit has changed in terms of the president's interest in the Federal Reserve since he was able to appoint Kevin Warsh as the new chair. But you're correct. The way that the decision comes out, it says basically that there's some position in between what the government and Lisa Cook had argued that they say, that the court concludes and says, well, there has to be some sort of notice and hearing provided if the president wants to proceed to fire a Federal Reserve member like this. It can't just be nothing. So whether and to what extent it goes back and then moves forward for more proceedings really depends on whether the Trump administration insists on continuing with this effort, or maybe they just back off because they have gotten a major, major victory in the FTC case.
Yeah. Let's turn to the announcement on mail-in voting. That decision, something of a major blow to President Trump, who we know has been dogged in his targeting of mail-in voting. What did you make of that ruling? And just give us the sort of broader context of, how we've got here.
Yeah, I agree with you that it was a sort of a bit of a surprise. And it is a bit of a repudiation to Trump's effort to really clamp down on mail-in voting. But I do think it makes sense to think of this decision as it comes against the broader backdrop of the Supreme Court's rulings in the areas of voting rights and redistricting. Because within this same term, we have seen the conservatives, the Republican appointees on the Supreme Court dramatically water down protections against discrimination in our voting rights areas and in redistricting areas. And mail-in balloting, actually, Trump is a bit of an outlier. The Republican Party as an institution is either agnostic or in favor of mail-in voting, particularly given the composition of their voters and the aging nature of their voters. So this is maybe a repudiation of Trump, but I think this is probably where the Republican Party wanted the case to come out.
Understand we have heard from the president via his social media platform. What's he saying?
Well, he's choosing to focus on the case that was a clear victory for his position, and that is the transgender athlete-related case. The president writes on his social media post in all caps, "Big win, : the United States Supreme Court ruled against men playing in women's sports." Wow, he says, that takes what he describes as a ridiculous situation off the table. So clearly the president views this as a win, as we discussed. It's been a big part of his political rhetoric and his views and a cultural stamp he has put on politics of this moment. We have not yet heard any response from the White House on birthright citizenship, where the president's executive order was struck down and where birthright citizenship, as we have understood it for more than 100 years, remains in effect today. Craig?
And for more now on how the White House has responded to today's rulings and the relationship between the president and the nation's highest court, we are joined again by Amy Howe and our White House correspondent, Liz Lander. So, Liz, as you all know, President Trump was personally invested in this birthright citizenship case. He even attended the oral arguments, which is rare for sitting presidents. I don't think it's, well, it might have happened before, but not in modern history. How is he
we know
responding
Trump
to
does
today's
everything
rulings?
his way, so
with
we can't go by
disappointment.
the
The only
norm.
thing we've heard from him so far is this Truth Social post that he posted this morning. And I know you all read that earlier, but in it, he talks about the future and what he may be able to do going forward and a pathway, he thinks, to still overturning birthright citizenship. He wrote out that Congress should start today to work on ending this. And he posted earlier in the morning, actually right before this decision came out from the Supreme Court, a post from a website called Just the News, and the headline says, quote, Trump's efforts to reverse birthright citizenship may succeed with or without the Supreme Court. And this story suggests that Congress could change the law with legislation called the Birthright Citizenship Act. This was introduced by two allies of the president, Senator Lindsey Graham and another House Republican, on the day that he was inaugurated in January of 2025. And this piece of legislation would amend the Immigration and Nationality Act. I think we are probably going to see the president push members on this, but it is unclear how that would fare given today's very definitive decision from the Supreme Court. There are other allies of the president's on Capitol Hill, like Senator Mike Lee, who is acknowledging that this sort of change would require an actual constitutional amendment. And more broadly, though, Jeff, I think that this is an interesting moment when we're seeing the president increasingly react and lash out at the Supreme Court. Back in February, I was in the briefing room when the tariffs decision came down and the president had a press conference, and he was very angry and upset with the Supreme Court justices, in particular, some of the justices that he had appointed to the court that ruled against him in that decision. There were more justices today who he had appointed to the court who also ruled against him in the citizenship case.
On this matter of birthright citizenship, how has the president's argument, how has it evolved over the years, and what does it mean now for his immigration agenda?
Honestly, the president has been saying the same thing about this since he announced his presidential bid in 2015. I was looking back at some of his comments from that time, and he said that he did not think that
One thing about Trump, he's always consistent from what he said in the past to what he does currently.
Which is what he is saying today, which is, I think, questionable, and argued that Congress could do the same thing. And he has also had some of the same campaign aides now become top White House advisors and aides on this issue, like Stephen Miller, who is a very powerful top immigration advisor to the president. Miller wrote today on X, on that platform, that this is one of the most destructive and outrageous decisions in the long history of the Supreme Court. We know that Miller and the president were crafting a lot of this kind of immigration policy while the president was out of office for 4 years, and they were teed up and ready to go with some of these policies on day one. President Trump signed this executive order on birthright citizenship on his first day back in office in his second term. And looking forward, we're also hearing from other members of the administration today who are talking about what they are going to do. The border czar, Tom Homan, came out and talked to White House reporters a few moments ago, and he said that the immigration agencies and DHS are going to triple and quadruple down on investigations into birth tourism. He framed this as a national security issue. And then right after he spoke, we saw a Department of Justice memo.
Birth tourism,
that was
I think, is the
issued
major
today
problem that they actually trying to
prosecutors
address.
To prioritize the investigation and prosecution of these so-called birth tourism schemes, Jeff.
Amy, do you see a through line or a pattern to the cases that the court has ruled in terms of victories or defeats for the Trump administration?
The president, these are certainly the tariffs decision, the birthright citizenship case were really some of his top priorities, as Liz said. These were also cases in which he was really swinging for the fences, so to speak. In the tariffs decision, the Supreme Court, the majority made a point of saying this was a power that no president since this law was enacted had ever invoked. In birthright citizenship, this was sort of going against what everyone had understood the law to be since the 14th Amendment was enacted in 1868. And so, to the extent that there's a through line, Lisa Cook, no one had ever tried to fire a member of the Fed's Board of Governors before. To the extent that there's a through line, I would say that this Supreme Court is willing to give this president
Just because nobody
quite
tried
a
it
bit of
before
power.
doesn't mean it can't be done.
They do have their limits. When he really starts to test the boundaries, as he did in the tariffs case, in the birthright citizenship case, in the Lisa Cook case, they may push back.
It's the end of a term. We sometimes hear about retirements. There's been a lot of focus on the conservatives on the court because the Republicans have the Senate majority. Any indication that there might be retirements upon us?
There's been a lot of speculation recently, in particular about Justice Samuel Alito. But as you say, this is often the time when we hear about retirements, the idea being that the Senate could hold hearings over the summer and have a successor confirmed in time for the first Monday in October when the court starts to hear arguments again. We haven't heard anything yet. There's still a window, certainly, in which Justice Alito or Justice Clarence Thomas, who's the other really senior justice on the court, could announce their retirement, but nothing so far.
Liz Landers, Amy Howe, thanks so much for your analysis and your guidance over these last few days as you've walked us through
starts October
these days now
for the
of
Supreme
major
Court
rulings. We deeply appreciate it.
Of course. Thank you.